Municipal Court, City of Abilene, Taylor County, Texas. In the name and by the authority of the state of Texas, before me, the undersigned authority, personally appeared affiant known to me to be a credible person, who after being by me duly sworn, upon oath deposes and says affiant has good reason to believe and does believe that one Chris Utes, hereinafter called Actor, on or about November the 10th, 2017, and before the making and filing of this complaint within the territorial limits of the city of Abilene, Texas, intentionally, knowingly, or recklessly possessed a location-restricted knife on the premises where a high school, collegiate, or professional sporting event or interscholastic event was taking place, to wit, Southwest High School at 4500 South Main Street. Said actor was not a participant in the event, or the location-restricted knife was not used in the event, and against the peace and dignity of the state.
Good afternoon. Would the prosecution, counsel for the prosecution, please make their opening statement?
Yes, Your Honor. Permission to move about the court?
I'm sorry?
Permission to move about the court?
Granted.
With the risk of violence, one can understand the caution about allowing potential weapons into a public area, especially...
Pull your microphone up so we can hear you a little better. Is there a microphone there?
Perhaps that one will suffice?
Is this one on? Okay. Is this better? Can you hear me? Okay. Is it okay if I just go ahead and restart my opening statement?
It is.
Okay, awesome. With the risk of violence, one can understand the need for caution about allowing potential weapons into public areas, especially high school football games with supportive parents, excited younger siblings, and tons of people. The defendant, Mr. Chris Utes, has received a citation for an offense against public safety, more specifically carrying a 6-inch knife at a high school sports game. A 6-inch knife can be used for violence, which is why possession of this weapon comes with increased responsibility that should be taken very seriously. It can be used, it can be lost, and it can be taken. There's a reason why we have a law that specifically addresses location-restricted knives. Situations can escalate fast, and a knife adds tension and violence to the atmosphere. He was prone to a spiral effect that could have resulted in more serious implications. Mr. Utes did not take having possession of this knife very seriously, and bringing it to a high school football game was inappropriate and inexcusable. It's the protection of our society, and as the state, our main priority and highlighted goal for this trial is the goal of public safety. It is our responsibility to show that Mr. Utes deserves the maximum sentence of 60 hours. Thank you.
Would the defense please make their opening statement?
Yes, Your Honor. May it please the court?
Yes.
Permission to move about
Yes, granted.
Today, you're going to hear how this case is a lot like a puzzle. You have all the pieces, you're putting it together, but sometimes there's that one piece that's missing. Today, we, the defense, have this missing piece, and if you allow us, we'll give it to you. Good evening, Your Honors, opposing counsel. My name is Cameron Alexander, and today with me is my co-counsel, Brianna Riddick. We represent the defendant, Chris Utes. Now, today on the witness stand, my client will tell you that she did, in fact, bring a knife to the football game that night. But I want you to also keep in mind that my client realizes how potentially dangerous this situation could have been. And with that being said, there are a few things I want you to keep in mind as the case proceeds. Now, the first thing is no excuses. My client understands that there were no excuses to the actions that he displayed that night. You will see that this is all one big misunderstanding and an accident. But like I said, she's going to tell you on the witness stand that there are no excuses for her actions. The next one is responsibility. My client didn't blame anyone for their actions. My client was completely compliant when he was approached by the officer. Now, the last thing to keep in mind is the mistakes as a whole and how my client is willing to prevent them. You're going to hear about the steps that my client has taken to prevent anything like this from happening again. And that is why, and the one thing you won't hear in this case is why exactly it's a 60-hour case. You're going to hear that there is no burden of proof, no concrete indication on why this is a 60-hour case. This is why we, the defense, are asking for 40 hours of community service. Thank you.
The prosecution call their first witness.
The prosecution calls Mr. A.M. Wynn. Does he need to be sworn in, Your Honor?
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
You may proceed.
Mr. Nguyen, for the sake of the court, please state your name, age, and occupation.
My name is A.M. Wen. I'm 32 years old, and I've been a police officer for 10 years.
Why were you at Southwest High School on the night of the incident?
Well, Southwest High School was having a football game that night, and it's pretty standard for them to ask for police to be in the area, and just to make sure that peace is kept and everything goes smoothly.
So, as your presence at the stadium, what is your role there as you are around the area?
Well, as a police officer that was walking around inside the stadium, I and my partner was scanning, people, making sure everything was going all right. No fights were starting to flare up, and no dangerous objects or suspicious behavior was in place.
What were the events leading up to the issuing of the citation?
Well, like I said, I was walking around with my partner, and we saw a group of kids group up and start talking, and crowds can sometimes get a little bit rowdy. So we decided to walk by, just scan it, make sure everything was cool and smooth. And when we did, we noticed one of the kids turn, the defendant. When he turned, it became.
This statement is narrative.
Your Honor, it's a narrative. He's trying to explain the story of what was going on.
Sustained.
Thank you.
So, when you looked at him, what did you see?
When he turned, it became plainly visible he had a large knife on him.
And when you approached him, what did you do?
Well, it's protocol to go ahead and obviously deal with this, considering it was plainly evident that it was a location-restricted weapon. So I asked him what was on his belt and to show us what was on his belt.
How would you describe the knife?
Well, the knife was long and narrow.
With the permission of the court, may the witness please stand.
Granted.
Where on your person could you indicate the knife was located?
Well, the knife was pretty much right in front of him, right about here, just hanging right in front of him, in plain view to anyone in front of him.
Would you please take your seat? As an experienced officer, would you consider, how would you describe the positioning of this object?
Well, this object, considering its size and intimidation factor, it looked like it was nearly a cool guy, a tough guy thing, an intimidation instrument.
How many people were at the event that night?
Well, I can't tell you exact numbers, but there were certainly hundreds.
Why, from your view as a public safety officer, is it a good or bad idea to bring a knife to a public event such as this?
Oh, it's extremely a poor idea. Knives, the presence of any weapon, including knives, particularly very large knives such as this, can make things more tense. If there's an argument going down, the presence of any sort of weapon, including knives, can make things tenser, make things flare more. And there's no guarantee that this knife wouldn't have somehow become lost, gotten in the wrong hands, or if tensions would flare.
This statement is also a narrative.
Your Honor, may I explain?
You may respond.
As a professional officer, he's entitled to an opinion with almost 10 years of experience to describe what this kind of thing could mean for our society.
I'm going to sustain the objection as to the narrative. You need to do it in question and answer.
Yes, sir. Is having a knife there on the premises a public safety risk?
Absolutely.
The prosecution passes, Your Honor.
Would the defense like to cross-examine the witness?
Yes, Your Honor. You worked many cases like this before, concerning teens and weapons.
Yes, in my 10 years, yes.
And this could have been a much worse situation.
Hence the reason why it was taken so seriously.
Yes or no, please?
Yes, it is.
And because you worked many cases like this, you've seen fights, haven't you?
Yes, I have seen fights.
And you've seen weapons pulled out, teens pulled out weapons on other teens?
Absolutely. Again, why I take
Yes
this
or no,
seriously.
please?
Still a yes.
And some may even try to hurt you, correct?
It's a danger to everyone in the area, ma'am.
And some may even try to hurt you.
Very, very rare occasions. Usually, like I said,
Objection, Your Honor. This is a hypothetical question, not at all relevant to the case at hand.
Overruled.
Thank you, Your Honor. So some teens may even try to hurt you, correct?
it's possible, yes.
But that wasn't the case with my client, huh? Not Chris.
No.
She didn't try to hurt you, did she?
It did not look like he intended to, no.
And he immediately complied with you, correct?
Yeah, when I asked him to show him his belt, he did take off his jacket.
And he did give you the weapon, correct?
He did give the weapon to us upon request.
And because my client was compliant and did not give you a hard time, you would agree that this case deserves a less punishment.
No, I would not agree this
Objection,
case.
Your Honor. This calls for a conclusion.
Overruled.
Thank you, Your Honor.
No, I would not agree this case because giving this a lesser sentence would downplay the significance of having a large and dangerous weapon in not only a crowded public area, but area with children, a large amount of children.
So this case so you're saying that this case falls on the same spectrum as someone who was harmful towards you?
Now I'm getting confused. Are you saying on the same spectrum as someone that's attacking people?
On this case as a whole, just period. Does this case fall on the same spectrum as someone who was harmful towards you when they had a weapon?
In seriousness, yes, it does. Because, like I said, this is very serious to bring a large, dangerous weapon into a child-infested environment. What would have happened if a child got it off his belt without knowing?
Okay. Isn't it true that you gave the knife back to my client?
Upon upon his exiting of the football stadium, yes.
And because she wasn't, being harmful or anything, that's the reason why you gave it back. Otherwise, you wouldn't have done so, correct?
Well, it's his private property. I can't just withhold it as long once he leaves the
Yes or no,
location.
please?
Yes, we gave it back
And
because
there's nothing about this case that deserves the max.
there are things about this case that deserve the max. I think we've already went over that. It's very dangerous to have a large, dangerous weapon in a child-infested environment.
And just to clarify, no one got hurt, correct?
No one had the chance to.
No one got hurt, correct?
Not with.
Objection, Your Honor.
please.
Asked and answered.
Sustained.
I'll pass to witness, Your Honor.
Would the prosecution like to redirect?
Why did you feel the need to write the citation?
As I said, this weapon is dangerous, and it's not only an influence, but there could have been so many things that I can attest to in my 10 years of experience I've seen happen that could have gone far worse than this.
If the knife were to be kept in place, is there a possibility that something could have happened with that knife?
Objection, Your Honor. This is speculation.
I'm going to overrule the objection.
Thank you.
In your professional experience as an officer for 10 years, would you say the knife being in the premises opens up the possibility of there being an incident with that weapon?
Absolutely, seen it more than once.
Did you know of the defendant's circumstances?
I've never met the defendant before, so no.
Do they matter in the situation of public safety?
Public safety should always take precedence over anything.
I think we're good. The prosecution passes, Your Honor.
Recross by the defense.
Thank you. Now, you stated that things could have been far worse, correct? Because you've seen it happen more than once.
Objection, Your Honor, asked and answered.
Overruled.
Thank you, Your Honor.
Please repeat the question.
You stated that things could have been far worse because you've seen it happen more than once, correct?
If they'd been, things have
Yes
been,
or no, please?
if possibly, yes.
Okay. And you would agree that you were pretty lucky to have such an individual who was compliant with you.
I was lucky to have caught it in time.
You were also lucky to have such an individual who was nonviolent, correct?
Yes.
Your Honor, I rest my case.
Any further direct examination?
No, Your Honor.
The witness may step down. The defense, please call their first witness.
Thank you, Your Honor. We proudly call Chris Utes to the stand.
If you'd raise your right hand. Do you swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated. Defense.
Thank you, Your Honor. Can you go ahead and tell us your name?
My name is Chris Utes.
How old are you, Chris?
I'm 16.
What school do you go to?
I attend Southwest High School.
What grade are you in?
I'm a junior.
And what kind of grades do you make? What are they looking like?
A's and B's.
Are you in any extracurricular activities?
Yes, I am.
And what are they?
FFA, I'm sorry, FFA.
And what exactly is FFA?
It is where we learn how to take care of animals and breed them, things of that nature.
And how long have you been a part of FFA?
3 years now.
Okay. Now, let's talk about the day of November 10th, 2017 at 7:45 p.m. Where were you at that time?
I was at a football game.
Why were you there?
I promised my cousin that I would see his football game.
Now, prior to the game, where were you?
I was at FFA.
And why did you have a knife on you?
Well, usually we have a knife to cut a rope or if an animal gets caught in a fence, some things like that.
And why did you have a knife on you at the game?
Honestly, I forgot that I had it on me.
And do you think that forgetting excuses your actions?
No, of course not.
How do you feel about your actions?
They were irresponsible and
what
dangerous.
things- Sorry?
And dangerous.
And what things are you doing to prevent this from ever happening again?
Well, one thing that I've done, when I get to FFA, I give my car keys to my sponsor, and I cannot get them back until my knife, my card to get in is given to him.
Okay. Now, this is a criminal offense. What steps have you taken to address the legal troubles that you're in?
Well, I pled guilty. Also, I have come to teen court, and I have, no matter what hours I get, I've decided to take a weapon awareness program.
And if this was an accident, why did you decide to plead guilty?
Well, no matter how forgetful I was, it's not an excuse to have it. In the end, I did have the knife, and in the end, I did go on school property with it.
I passed the witness, Your Honor.
Thank you. Cross-examination.
Now, in your testimony, you said that this was dangerous of you, correct?
Yes.
Do you understand the implications of having a 6-inch knife in public areas? Do you understand the negative effects it could have on that public area?
Yes, of course.
And could you name some of those negative influences that it could have on people? Or not negative influences, why that law is there in the first place?
To keep people safe.
To keep people safe. And how long was FFA that day? FFA that day. How long was your project hour?
Well, we were there for after school for about 2 hours, but it's usually longer, but I left early to get to my cousin's game.
And at what point did you put the knife into your belt?
Objection, Your Honor, this is irrelevant. We already know that she had the knife, so there's no point in
I
it.
have a response, Your Honor, if you
When?
allow me.
You may respond.
I'm trying to build and create the situation. By understanding she put it on right before she started driving to the incident, or if she had it on for previous hours, that could establish if she did actually forget the knife on her, or on him, sorry.
I'll overrule the objection.
Thank you, Your Honor.
Can you repeat the question?
Yes. How long did you have, at what point did you take your knife and put it into your belt?
When I got there that day.
When you got to FFA?
Yes.
And so, but did you not change clothes? When you went into your car to drive, did you not think about having a knife on your belt?
I didn't think about it. I forgot it. And I didn't change my clothes. I was kind of rushing to get there.
So for clarification, you forgot about a 6-inch knife on your belt, on your person.
Yes, I did.
Okay. Do you believe that this shows responsibility?
No, I don't believe that it shows responsibility.
How long, you said you've been part of FFA for what, 3 years? Is
Yes.
that correct?
Yes.
So for 3 years, you've been around large knives.
Yes.
And so at this point, you should know the responsibilities that surround a knife, correct?
I should, yes.
So why is it that you had no responsibility on November 10th, 2017?
I don't know. It just slipped my mind.
The prosecution passes the witness, Your Honor.
Redirect.
Thank you, Your Honor. Okay. Now, within the 3 years that you've been a part of FFA, are you used to having that knife on you?
Yes.
Is it like second nature?
Yes.
So why did you forget the knife this time?
Well, because I'm so used to having it on me, I really forgot it was there.
And just to clarify, what were your intentions when you were going to the game?
Just to watch my cousin play.
I'll pass the witness, Your Honor.
Recross.
Did you know earlier that day that you would be attending that high school football game?
Yes, I did.
And so did you not think about preparing, getting ready to go attend that sports game?
Sorry.
Did you not think that you would be in a public area?
I knew that I would be in a public area.
And so you did not seek a place to put your 6-inch knife, or not yours, that was bad terminology, to put the 6-inch knife.
As I said before, I forgot it was there.
And you stated yourself that your action was inexcusable, correct?
Yes.
And you would agree that public safety should always be upheld.
Yes.
Now, according to the testimony of the officer, the belt was visible when you moved.
Yes.
Is that correct? Would you agree with that?
Yes.
And so did none of your friends, did nobody point out that you had a weapon belt on you?
Objection, Your Honor. This question calls for hearsay.
Your Honor, a response if you would allow me.
May I respond.
My response is I'm trying to establish the situation. If she had it in visible sight, as our witness has stated, then she would have had previous knowledge about having a weapon on her. Not a weapon, but a knife on her.
I'll overrule the hearsay objection.
Thank you, Your Honor.
Can you repeat the question?
Did no one tell you that you had a 6-inch knife or you had a weapons belt on you?
No one told me.
No one told you. And this is despite it being in visible view.
Objection, Your Honor. We have already clarified that it was visible.
And what I'm trying to stress is that it was visible. I'm trying to, once again, establish a situation that friends could have seen it, family could have seen it, pedestrians, everyone could have seen it if the officer could have.
I'll overrule the objection.
Thank you.
Thank you. Now, one more time. Since it was visible to the police officer, would you agree that everyone at that high school football game could have seen that you had a knife on you?
Yes, they could have seen.
And this could have affected their sense of safety.
Yes.
Any further redirect?
No, Your Honor.
The witness may step down. Would the prosecution make their closing statement?
Your Honor, may the prosecution take just a moment to prepare.
You may.
Permission to move about the courtroom, Your Honor?
You may.
Thank you. Can you hear me? Just for the record, how much time do I have left?
You're just at the 5-minute mark.
Perfect. Judges ready? For every parent in the United States of America, the most important part of their life is their children. At Southwest High School's football game on that Friday night, every single person in that stadium was someone's child. And as the state, the primary role and purpose of our existence is public safety and security. The bringing of a knife into a public area such as this is a direct violation of that public safety that every single American deserves. Looking at the facts of this case, we can outline how neglect and intentionality has been dangerous towards almost every single person in that stadium, and that the need to take it away and the need to deliver a maximum sentence is important. First of all, let's understand how in the legislation that's been given to us, there are 3 different ways that we can be prosecuted: for knowingly bringing it in, intentionally bringing it in, and recklessly bringing it in. Meaning, if she knew that she put it on her belt at some point, she knowingly knew she had it on her belt at some point, meaning that she knew she had it even if she had forgot about it later. Furthermore, even if it was unintentional, she still brought it into the area and did not have the intent of taking it off and making sure to be careful beforehand, showing a reckless behavior in danger to the people. Finally, recklessness, looking at the aspects of the interaction of that she had. If she had been less reckless and not held it on herself and not been forgetful, she could have saved risk and issues of safety and social safety to the people around her. The image of the knife on the front of her belt directly in front of everyone is a form of intimidation, whether intentional or not. And that existence of being there in the presence of the knife is what causes danger in the first place. What is the bottom line today? The bottom line is that if the knife was not present, everyone would have been more safe. Since it was there, everyone was in greater danger. Public safety is the most important thing that we deal with today. And you're going to give a maximum sentence because the true thing that we have to maintain is justice in public defense. I ask you for a full sentence of 60 hours. Thank you.
Thank you, counsel. Would the defense like to make their closing statement?
Yes, Your Honor. May it please the court?
They may. Permission granted.
Thank you. Now, at the beginning, I told you this case was a lot like a puzzle and that we had this missing puzzle piece. Well, let's look at what we found today. Now, the point of teen court is punishment. We have to see exactly where this case falls on the spectrum. And a lot of what you heard from the prosecution was exactly what she did and how, she knew it was irresponsible. Now, we understand why she's here. I mean, like I said, that's exactly why he's here. But the things we have to look at are the mitigating circumstances. Now, the first thing I want you to remember is no excuses. Everything that the officer said is true. And my client even reaffirmed this by going on the witness stand and stating that, yes, it was irresponsible. Yes, it was reckless. But he pled guilty. My co-counsel asked, why on earth would my client plead to something that was an accident? Well, my client understands how dangerous the situation could have been. But like I said, it was an accident. And because it was an accident, we ask that you remember that my client chose to learn a lesson from this. Now, because this was an accident, she could have fought it all the way. She could have said, no, I'm not going to plead guilty. But she wanted to learn everything possible from this offense that she could. And there was no blame game either. He didn't say, oh, I forgot it because my friend did this, or I forgot it because, at FFC, my friends were distracted. There was none of that. He admitted to having that knife and is here today because of that. The next thing is responsibility. My client immediately complied, didn't deny owning that knife, and accepted responsibility for every single thing that the prosecution asked. And the last thing was, how will my client prevent this mistake in the future? Well, you heard him state some pretty logical things. From now on, when he goes to FFC, he's going to turn in his car keys so that way he gets the knife, and when he's ready to leave, he'll give that knife back and get the car keys to prevent this from ever happening again. The defendant has already determined where the community service will take place at. It'll take place at a weapon awareness program. And like I said, teen court is voluntary. My client wants to learn everything possible from this. Now, briefly, if we look at the officer's testimony, when asked, is he lucky to be in this situation where my client did not cause any alteration, he in fact said, yes, this is not a 60-hour case. They talked a lot about couldas and shouldas and wouldas. Well, none of those things are relevant because we're here for what did happen and what things my client has done to change this type of behavior. And her intent was simply to go support her cousin. She's been doing this for 3 years, and she made this mistake one time. That is why this is a 40-hour case. That is where this case falls on the spectrum, and that was the missing piece that you needed in order to make the correct decision. Thank you.
Thank you, counsel. Is there any rebuttal from the prosecution?
Yes, Your Honor. Judges ready? True justice requires us to take an open look and be unbiased. Looking at the broad weighing of the arguments today, we have an argument between public safety and regretfulness. Now, I do fully believe that the defendant is a good person. I believe that she had no malintent in doing so. But the reckless behavior that was present, that was shown in that day, shows what it's like in real life. As the defense said, we have at teen court, you're able to present yourself and be good, and anyone can present themselves as responsible and good, which she has. But what is the true test is real life circumstances. Some nights like December 15th of 2017, in which she brought a knife to a football game and put other people at risk. Being responsible in court doesn't mean you're responsible elsewhere. Look at the true facts that have occurred and look at the broader consensus. We understand that the true purpose of this court is public protection. While we take 40-hour and 60-hour cases, we have tons and tons of Class 6 misdemeanors, whether possession of drug paraphernalia or use of intoxication
Objection,
or drinking
Your Honor.
and
I
driving.
hate to be rude and object during the during the rebuttal, but we're not here for any intoxication or anything like that.
I'm addressing the 40 to 60-hour case that he was talking about.
Objections overruled.
So the way the knife weighs among those is that while some use of intoxication or drugs may be down towards the bottom, they don't show harm to other people. This was a direct issue of harm to other people, of risk to society. That's what matters most. Because while tons and tons of different misdemeanors weigh and show different aspects, this one is a direct harm on society, a harm on people, a harm on the innocent. The truest thing we can do today is deliver justice. And justice requires a maximum sentence of 60 hours. I implore you, deliver justice.
Thank you, counsel. The court will be in recess.
Congratulations to both teams. I can tell you that the judges had a very hard deliberation. Both of you presented very well, and you should all be very, very proud of yourself. I can also tell you that the decision was not unanimous. However, congratulations to Fort Worth.
I cannot emphasize enough how hard this was. Everybody had strengths and weaknesses. There were differences as well in the backgrounds of the judges as to what they liked to see and didn't like to see. But in general, given the short period of time you had to prepare, I've seen lawyers in real cases that you guys eclipsed hands down. I mean, you should be very, very proud of yourself. There isn't a loser here by any means at all. Everybody, both sides, were very much winners. There was one thing that we were all unanimous on. We've seen you do a whole lot better than a lot of lawyers in real life. I'm not kidding. I'm not kidding. Things perhaps that I saw and took somewhat a little bit note of is I like attorneys to be comfortable with what they're saying and somewhat sort of even conversational. But yet I do, at certain points, there are times to emphasize points by raised voices, which I do like. I very commonly will use my glasses as a prop, take them up, down, changing the tone of voice, but when I raise my voice, everybody in the courtroom knows it's important. So that inflection was something that I liked, but yet I also very much noticed your abilities to control witnesses was very, very good. I commend both sides on that. And again, it was horribly difficult. It really, really was. I'm going to pass to the next judge.
All right. First of all, I would also like to say congratulations. I know how much work you guys have put into this, and it's really, really cool that you're doing this, and you're going to be better off for it down the road. Just by a show of hands, do any of you want to be lawyers? Kara and I are actually law partners, so we try cases together all the time, and we're criminal defense lawyers. And so this is kind of what we do. And you guys just did a great job. Some of the comments I would have, first of all, the witness for the prosecution, Kara and I both agreed that we thought you were a really, really good witness. And I say that because I was really irritated with you because you were just like a cop on the stand. Couldn't pull a straight answer out of your mouth with a pair of pliers. You know, so that was really well done. And if you went down to 401 West Belknap, where we try cases all the time, you would see cops testifying just like that. And it's very frustrating as the defense because, you know, the defense, you're trying to just get them to say what the truth is, and they won't answer the question that you're asking. And that is exactly what police officers do. And I'm not running down police officers, because I love police officers. But anyway, just a couple comments from the defense. I would have liked to have had more personalization of the defendant. You guys were calling in closing arguments and opening statements, you were saying my client. Never do that. Never say my client. You know, in fact, I always use the first name. You know, it's like, you know, can Kara get a fair trial from you guys? Not can my client. You know, you care about them, and you want the jury or the judges to know that. For you guys, I thought you did a really good job. I would have liked to have seen a little more of an approach where it's, look, you know, this might have been reckless, okay? It might not have been intentional, but that's not what this is about. This is about public safety, and we need to, you know, take your foot off her throat a little bit and just say, this is why this is so important, not necessarily even completely specific to her. And I would have liked to see maybe a little more of that. But man, just fantastic job. I can remember I did something like this at school when I was a kid, and I didn't do nearly as good a job as you guys did. So congratulations to all of you. Kara.
So I'm kind of, you know, this was so hard for me that I sat in the back and I'm like, I'm not doing this again because it was really, I told the monitor that I'm like, it was just really hard. And I work a lot with, you know, Southlake, I work a lot with the teens, but I just thought that both teams were unbelievably good. I thought that, I mean, for me, it was literally 1 point. And one of the things that I thought both of y'all's closing arguments were just excellent. They were very, very good. I thought that you guys brought out some good points. I love the prosecution bringing out the safety of the community, and I think you were trying to get to that point that, you know, we've had these school shootings, and that you should be, you know, I thought that was a really great point that you guys brought out in prosecution, and I think that that was the great way to handle it. I thought that the defense did a great job in trying to personalize, and here's the other piece of the puzzle, and I really loved that because you tied that in at the end. And you're, on your closing, your coulda, woulda, shoulda, you know, we're not talking about these coulda, woulda, shouldas, we're talking about this person, and I thought that was a really good point. I think that the objections made were excellent. I think that you obviously get what the rules of evidence are, and you obviously, you've been trained to do that, and that's a really hard thing to do right when you're in the middle, in the thick of it. So, I mean, I just think you guys are excellent. If you're thinking about going into law, do it. You know, you guys have the confidence, and I think y'all all did a great, great job. So, thank you for doing this for us.